but with the 13th Amendment qualification that slavery is okay for prisoners. Neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted. And now, with over 2 million men and women in prison, and practices anomalous in the rest of the so-called civilized world, including the death penalty, supermax confinement, cruel, inhuman and degrading treatment, and above all, indefinite detention at Guantanamo, what happens in our prisons matters more than ever. But perhaps there's a more personal background to my current work on prisons, civil death, and the law. As a child growing up in Atlanta, I recall men wearing zebra stripes working along the highway. These chain gangs continued in spite of denials of their existence until the mid-1960s. My father would warn me not to look, but I ignored him, and years later, when I thought of the South, I thought of men shackled in the sun. While in Tucson during the spring of 1995, I heard that chain gangs were returning to Arizona as part of Governor Fife Symington's Get Tough on Crime philosophy. I was intrigued by the transport of a past idea to the contemporary Southwest, how images of humiliation, the chain and rock busting popularized in film and fiction, could construct a new phantasm of criminality. The use of chain was the exploitation of a powerful symbol, and once attached to inmates, it claimed them as characters in a drama of degradation, a memorial to slavery in the convict lease system. At that time, I gained unexpected access to super maximum security units. I had sought actually to teach writing in the state prisons in Arizona, and I was told that that was no longer allowed because prisoners had no need to do anything in terms of education except pass a general equivalency diploma. As an educator, I thought that I wanted to know more about the reinstitutionalization of deprivation for inmates. I came to the conclusion that what I had seen amounted to nothing less than the most radical redefinition of personhood since the abolition of slavery in the Americas. It's a tall claim, but today I hope you'll bear with me as I try to talk about a particular Supreme Court case that I think bears some consideration. My work began with two questions. How has the identity of the slave been reborn in the person of the prisoner? What are the conditions under which categories of personhood can be legally reconstructed? I wanted to understand what it meant to be dead in law. And now, why does this attention to the law matter now more than ever before? As the Bush regime continues to incarcerate the innocent in Guantanamo Bay, to rewrite international law, and to use what are called enhanced interrogation techniques, we read complaints about an administration outside the law, secret CIA sites that are lawless, and war prisons that create a legal vacuum for approximately 14,000 detainees in United States military prisons in Iraq, Afghanistan, and offshore in Cuba. However, I've thought that being outside legality might not be the point. Before the global war on terror and the export of local prison practice to a network of overseas prisons, numerous Supreme Court decisions in dialogue with prison correctional policy had already retooled civil death for the incarcerated. To the extent that probable cause and due process protections of the Constitution are ignored and abolished in the wake of the war on terrorism, the directive achieving such ends is illegal by any post-Magna Carta standard. The extremism of current practices of punishment in the United States, even before September 11th, derives not only from a colonial legal history that disabled the slave while inventing the legal person, but also from the extremely legalistic nature of the American system in general. We, the people of this country currently hold prisoners in supermax detention and 23-hour lockdown without any human contact other than violent cell extractions. We, the people of this country, as you know, execute the condemned by a protocol of lethal injection too painful, too prolonged, and too uncertain to be used on dogs. Strapped to the gurney, they suffocate, but since their skeletal muscles are paralyzed, they are unable to move or speak. They die in excruciating agony. In the current climate of what I'm calling hyperlegality, with Attorney General Michael Mukasey still unable to say whether waterboarding, at least as he says for other people, is a form of torture or illegal, and Justice Antonin Scalia, in an interview with the BBC, arguing that so-called torture is okay, we need now more than ever to ask what we mean by law. Since only cruel and unusual punishment is prohibited by the Constitution, but not cruel and unusual treatment used to get information about the proverbial ticking bomb, then why not, Scalia asked, stick something under the fingernails, smack them in the face. He's a very fine lawyer, however. Very, very astute. I've met him a couple of times, but he does have a way with words. What kind of world would we find ourselves in if too much law were the problem? If legal interpretation not only took place, in Robert Cover's words, in a field of pain and death, but also supplied the terms for rethinking the meaning of human. What fascinates me is that the legal-minded discourse on terror is rhetorically powerful and widely embraced. The White House lawyers, and they're some of the best, have displayed a preoccupation with legality and a delicacy about legal proprieties whose result has been to facilitate a state of official and pragmatic lawlessness. What is remarkable now as we observe the extension of legal reasoning into what we think of as unprecedented domains is how historically bound is law's ability to invent persons who yet remain in a negative relation to law. And I'm very interested in this history of personhood because slaves were always legally persons. Some of us consider slaves to have only been things, but what's remarkable is that the law, certainly in the United States, went through tremendous and unprecedented changes in order to constitute what we think of as anomalies, but who were legally defined as persons. Now, the question I ask today is, can we take law as a subject, the protagonist of a plot that we might think of perhaps has so little to do with law as we understand it? What I want to offer today is a possibility of thinking about how atrocities, rather than being a departure from legal thinking, can be in some way an accumulation of remnants, of idioms of past points of law at other points in our history that can transcend violations of what we think of as the rule of law. The story I want to tell today is ultimately then legal, not, if it might sound it, just political. Speaking broadly, I would say that only in legal documents and legal forms are the social and economic arrangements of past times made visible to us. The black codes, the penal sanctions, and other forms of unfreedom form the skeleton of the body politic. But we can't be too scornful of bones, even if they're dry bones. One of the things that I think also fascinates me is how law occupies a place very often apart from our normal language, or we think that it is a place that if we're not a trained lawyer we can't understand. But it is quite possible that statute and case law were more crucial than social relations or even beliefs in creating rituals of exclusion and, most importantly, putting certain kinds of persons outside the pale of human empathy. In June 2000, the New Yorker ran an ad that I tore out and carried with me as I moved from Tucson to Philadelphia and then to Nashville. Toyota advertised their new Avalon, the most spacious, luxurious sedan we've ever created, picturing the interior, seats in luxurious leather, and a man sitting comfortably behind the wheel. Along the top of the two-page spread were the words, "Confine the body and you shrink the spirit." When the ad appeared, I had just been visiting Special Management Units 1 and 2 in Florence, Arizona, just about an hour's drive from Tucson, for 4 years. I had been helmeted and vested, warned about paper darts, urine, and feces thrown out of cells by prisoners. I had been prompted to try out leather shackles made by the Humane Restraint Company. But it seemed unlikely that I would be threatened by inmates, since the cells where the worst of the worst were locked down for 23 hours a day without any human contact, except the often violent cell extractions, had doors covered with thick steel plates, perforated with small ventilation holes, described by one officer as irregular Swiss cheese. These units are clean, well-lighted places. They're not the holes of Murder in the First or Shawshank Redemption. I walked down the corridors on impeccably clean floors, no dirt anywhere. There was no paint on the concrete walls. The light seemed too bright. Although there were skylights in the corridors, the cells had no windows. Nothing inside the cells could be moved or removed. There was nothing inside except a poured concrete bed, a stainless steel mirror, sink, and toilet. What the Toyota ad described as the elegantly appointed cure for claustrophobia, therein lies the silk, I suppose, seemed timely if obscene. The ad appeared at a time when prison administrators and politicians were urging the public to support these extremely expensive and cramped high-tech units. A deputy warden joked with me about freeze-drying inmates, keeping them sealed off from the rest of the population. I kept thinking that shrinking the spirit seemed an appropriate euphemism, since everyone knows how extended isolation can drive prisoners crazy, not only because of the stressful environment of solitary confinement, but because of also excessive abuse and officers wound as tightly as those they confined. I corresponded and spoke with inmates whose experience had made me understand what it meant to live with minimal physical requirements, food, clothing, warmth, but without much else. This lack included other personal, perhaps more devastating forms of dispossession. One inmate lamented the loss of his own paintings and the photos he had never received from family and friends. An officer from SMU-1 corroborated his words, but not before he had shown me a room in the special security unit set aside for confiscated gang art and contraband boards. On one wall of the SSU was a sign set above the photos of prisoners who had mutilated themselves, row after row of slit wrists, first-degree burns, punctured faces, eyes emptied of sight and pouring blood. Idle minds make for busy hands. How much, I wondered, can you take from a person without running afoul of the law? This game got very depressing. As long as prisoners are deemed too dangerous for the general population, in other words, as long as officials classify them as such, the courts do not judge indefinite isolation, cruel and unusual punishment, nor do they find this confinement atypical and significant enough to satisfy the need for due process protection. After all, these incorrigibles are not being punished. Many of them have done nothing wrong, but they are assumed to be threats, alleged gang members, mentally ill, or sometimes they're just unpopular with prison officers. The point is that once officers substitute the word administrative for disciplinary, they invent a way of life, not simply what we understand as the practice of solitary confinement, which has legal limits of duration, but a tough regimen of enforced idleness and monotony that supposedly answers the needs of security and can last forever without any prospect of release. Security, a deputy warden once remarked, is not convenient. But I want us to think about, what does it mean to be stripped of life-giving illusions? How much can be taken from prisoners without destroying what Justice Thurgood Marshall once called their human quality? Or to put it less abstractly, how far can the courts of the United States go in curtailing the constitutional rights of prisoners? What is the residue of rights for those convicted of crime and restrained in their liberty? Does the Constitution even apply to prisoners? Though the language of rights is perilously abstract, the practice of taking them away is very concrete, and the effects of that removal are visited not merely on the bodies, but on the minds of prisoners. That's what concerns me most. It is easy to think of criminals as brutes, or as one prison director described to me as lazy bums, or an attorney general as Hannibal Lecters. But something very bad happens to the texture of society when our prisons begin to make literal what are just exaggerations. And that is what is happening as the Supreme Court decides that law libraries are no longer necessary for meaningful access to the courts. And now, in the case I want to speak about, as prisoners are deprived of reading materials. Politicians from George Bush to the lowest candidate for local office still gain popularity from get tough on crime attitudes. They justify their toughness by labeling inmates, by calling them names, and qualifying them for a new legal status. A deputy warden I once interviewed in Florence, Arizona, was only too eager to typecast inmates. Now, you call this a get tough posture. I don't think that's real tough to say, murderer, you're illiterate, you're a dummy, you've opted to be a criminal because it was easy for you. Again, what happens when a society gives substance to the rhetoric, reality to a metaphor? Because I think, as we all know, dehumanization is not easy to accomplish. And not all those incarcerated in super-maximum security units are dangerous and violent to themselves or others. Many of the inmates I have known who live in extraordinarily brutal conditions continue to resist the images others have of them. But what happens when the U.S. Supreme Court continues to erect barriers that separate prison inmates from the protections of the Constitution? And here I come to the case that I hope I'll have a chance to discuss with you today. On June 28, 2006, in the case of Beard versus Banks, the Supreme Court decided that denying newspapers, magazines, and personal photographs to prisoners in Level 2 of the long-term security unit, the prison's highest security unit, located on the grounds of the State Correctional Institution in Pittsburgh, did not violate the First Amendment of the Constitution. The next day, in Hamdan versus Rumsfeld, the same court granted prisoners at Guantanamo Bay the right to habeas corpus protection. It ruled that the military commissions created by the Bush administration failed to conform to Common Article 3 of the Geneva Conventions, which required a regularly constituted court affording all the judicial guarantees which are recognized as indispensable by civilized peoples. The proximity of the two cases, despite their differences, is notable, and I think question our assumptions about human rights and the extent of their applicability in both domestic and international law. But this is not my concern here. I think that domestic prison cases are remarkable in their prophetic potential. They prepared the ground locally, and I can prove this, for U.S. treatment of prisoners at Abu Ghraib, Guantanamo, and other as yet unnamed detention sites. These domestic prison cases continue to be ignored, although their legal reasoning shapes policies critical to the current substitution of penal for civil life, not only in the United States, but in other countries which willingly or unwillingly are recipients of our attention. I don't know how many of you have read the narrative of the life of Frederick Douglass, published right after he escaped from slavery in 1845. The most harrowing pages are those that cover the ban on reading, the withholding of knowledge from slaves. To be shut up in mental darkness was to be turned into a brute. Describing how his mistress, Mrs. Sophia Auld, changed from angel to demon, Douglass recalled, "Nothing seemed to make her more angry than to see me with a newspaper. She seemed to think that there lay the danger." In April 2000, the Pennsylvania Department of Corrections decided to increase its control over prisoners held in its long-term segregation unit by initiating extreme restrictions on reading, as well as personal photographs. Prison officials had decided that newspapers could be dangerous, and not only for the reasons Douglass had implied. LTSU was reserved for the most incorrigible and recalcitrant inmates, and at the time, LTSU, too, housed the worst of these intractable prisoners, who were categorized as threatening to inmates and correctional officers or belonging to a security threat group or other unauthorized organization. Prison officials had decided that newspapers could be wound up, turned into projectiles, used as nightsticks, to make fires, to hide contraband. But the deprivation of personal photographs and secular periodicals served another purpose, or so authorities argued: rehabilitation. Prisoners like to read about current events, to know what is going on in the world. They also like to look at photographs of their loved ones. If you took these things away, the theory went, the especially recalcitrant prisoners, those who have few other privileges to lose, would behave. So in October 2001, Ronald Banks filed a civil rights complaint in the U.S. District Court in Pittsburgh on behalf of himself and other prisoners in LTSU 2. He challenged the policy's constitutionality after correctional officers refused to deliver his Christian Science monitor. It might seem a trivial thing, but within the context, I think you'll see it's not. Jeffrey Beard, the Secretary of the Pennsylvania Department of Corrections, argued that the policy was necessary to promote rehabilitation and ensure prison safety. The question was, did this comprehensive prohibition violate the First Amendment? And the next question, was reading secular newspapers and magazines a right under the Constitution or a privilege granted by prison officials? Prisoners in LTSU 2 are kept in solitary confinement for 23 hours a day and limited to one family visit a month. These inmates do not possess any magazines, newspapers, or books except 2 paperbacks from the prison library and books of a legal or religious nature. No photograph of friends or family members are allowed. There's no access to radio or television broadcasts, nor to telephones, except in emergencies, or when related to legal representation. And I think the most serious thing is that although officials claim that you can graduate out, in fact, you can remain there indefinitely. The history of First Amendment jurisprudence concerning the incarcerated is fascinating. It's always a test, it seems, between reasonableness and irrationality, between what is necessary and what is arbitrary. And what we trace in these opinions are changing concepts, I think, of the aims of incarceration and the rights of prisoners, as well as the extent to which prisoners should or should not be considered persons. Now, I've always argued, and lawyers always argue with me, I continue to argue, that the rules of law carry with them philosophies of personhood. They are not simply rules for process. How far rights of expression or other capacities deemed necessary to civil life are granted to prisoners necessarily affects how society sees their status. What are the legitimate rights, then, of the state concerning the interests of the incarcerated? What is the legal status of prisoners? For Thurgood Marshall, prisoners are entitled to use the mail as a medium of free expression, for example, not as a privilege, but rather as a constitutionally guaranteed right. Censorship, he wrote, amounted to nothing less than what he called an artificial increase of alienation from society. And he concluded, I think, famously, that the First Amendment protected the needs of the human spirit, a spirit that demands self-expression. In those days, such an affront to dignity could not be allowed. When the prison gates slammed behind an inmate, he wrote, he does not lose his human quality. His mind does not become closed to ideas. His intellect does not cease to feed on a free and open interchange of opinions. His yearning for self-respect does not end. Justice William Douglas concurred with Marshall since, as he argued, prisoners are still persons. Should rights survive incarceration? Rights matter even, especially for those we would rather perhaps not think about, those convicted of crime. What are the limits of deprivation? For Justice William Brennan, these questions had to be asked. As he once said, prisoners come into the light when they make a constitutional claim, and when they do, they invoke no alien set of principles drawn from a distant culture. As he wrote, their world is our own. They ask us to acknowledge that power exercised in the shadows must be restrained as diligently as power that acts in the sunlight. The Bill of Rights, and especially the First Amendment, as applied to the states through the 14th Amendment, replenishes to some degree the personal identity that prison takes away. On October 22, 2003, the Third Circuit Court of Appeals in Philadelphia finally heard arguments in Banks versus Beard. The questions put by Judges Julio M. Fuentes and Max Rosen. Rosen was a Roosevelt appointee. He died on February 7, 2006, at 96, registered shock and disbelief at such an amorphous and apparently ill-defined rationale. They asked question after question, seeking to clarify what seemed to them such an extreme policy. How could such a sweeping restriction, they asked, of prisoners' First Amendment rights be justified? Weren't there other options available than such a broad response to the state's alleged interests? How did prison officials define religious as opposed to secular? All the Deputy Attorney General for the state of Pennsylvania could say to the question about the evidence that such deprivation helps correct behavior was, there's a hope. So speaking through Fuentes, with Rosen concurring, the majority sided with the prisoners and reversed the U.S. District Court decision, which had found the ban on newspapers and photographs reasonably related to legitimate interests. The court found no reasonable relationship between the ban and any legitimate penological interest of rehabilitation. As they wrote, inmates are not requesting unlimited access to innumerable periodicals, but for the ability to have one newspaper or magazine and some number of photographs in their cells at one time. They also found that the testimony of Joel Dixon, who at that point supervised the restricted housing unit, and this was the only deposition in the case, did not support his deprivation theory of rehabilitation. There was no testimony as to the frequency of fires in LTSU, nor testimony about any particular fires in or out of segregation. And the same is true for the materials' potential use as weapons. Judge Samuel Alito dissented 8 months after the Court of Appeals decision. President Bush nominated Alito for the Supreme Court and appointed on January 31st, 2006. He recused himself when a year later, Beard v. Banks reached the Supreme Court. For Alito, sanctions for prison misconduct did not need empirical evidence as long as the regulation provided some incremental deterrent. A prison official has only to make a claim that could be rationally related to the purpose of rehabilitation or security without any actual basis in fact. We might wonder, and I am certain that you do, wonder perhaps how a newspaper could be shaped into a blowgun, spear, or catapult for human waste, or how, given that legal materials are allowed, those materials might not be used for the same purposes. But why would inmates be less likely to use religious newspapers for nefarious purposes than secular? Why couldn't an inmate use writing paper, a prison handbook, blankets, bed sheets, or legal, as I said, periodicals? Why permit, I think the more interesting question, the Christian Science Monitor magazine, but not the Christian Science Monitor? If religious material is also a part of First Amendment rights, the judges had asked, why deprive them of regular reading material? The attorney for the state answered, we think that they are not so depraved as to fling human waste with the Koran or set fire to the Bible. So the attorney for the prisoners intervened, but I'm Jewish, and we use the Jewish Daily Forward, which is allowed to wrap up and throw out garbage. At this point, the case was nearing, as some reported in the Pennsylvania newspapers, farce. But I think there's method in the apparent madness. Level 2 inmates can read leisure books or romances, but they're prohibited from reading anything that refers to current political or social events, anything that would allow them to remain informed citizens. It seems to me that something odd occurs in this kind of punishment, something more perhaps than simply getting prisoners to obey rules. The central matter is the ominous leeway given to prison officials to deprive inmates not, it's true, of the basic necessities of human life, but of what preserves individual identity, the development of intellect, of spirit, of what one might call the human spirit. Also at issue is the kind of thought deemed possible for those categorized as the worst of the worst. Plato and Shakespeare and the Declaration of Independence are out. Harlequin romances are in. How do prison officials understand cognition, thinking, when it refers to prisoners? To me, these questions need to be asked. What about their assumptions of the mental capacities and intellectual desires of prisoners who have just been labeled incorrigible? 2/3 of the prisoners in the Arizona special management units are convicted for nonviolent crimes. As the American Civil Liberties Union argued in support of Banks and other prisoners before the Supreme Court, to deny prisoners all traditional outlets for learning about political affairs and other news is to deny their very citizenship. To say that because they're deemed recalcitrant, their knowledge and understanding on matters of public affairs no longer matter. You probably also know that disenfranchisement laws in many states do not allow prisoners who are pardoned to ever vote again. But the question is what happened in the Supreme Court, and I'm going to conclude here. On March 27, 2006, as I said, Pennsylvania went before the Supreme Court to defend its policy of depriving inmates of most newspapers, magazines, and photographs against claims that the restrictions violated the First Amendment. The court's decision, in spite of the doubts raised in oral argument, shocked many human rights advocates. A 6-2 majority approved indefinite confinement in the LTSU without even asking for a trial. Justice Breyer wrote the opinion, which Chief Justice Roberts, Justice Kennedy, and Justice Souter joined. As I said, Justice Alito took no part in the decision. If free speech and free press are crucial to the definition of the First Amendment and among the privileges and immunities of all citizens, then the extent of the deprivation permitted by the court in Beard v. Banks is far-reaching in its effects. And I should add, the present policy at issue here is unique. It's unprecedented. It's a long-term and indefinite deprivation of virtually all news from the outside world. It is a deliberate attempt to strip prisoners of the most fundamental attribute of citizenship and even of personhood, the right to know, to learn, to think about what is happening in the community, the country, and the world. For those who will be released, I think, as one lawyer for the prisoners asked, think about what kind of neighbor this prisoner will be, who has not only been locked down outside of all human contact, but has basically been turned into a Rip Van Winkle. Beard v. Banks relies ultimately, it seems to me, on the substitution of something we could call just reasonableness for plain evidence. The reasoning is arbitrary, for prison officials do not provide any evidence that their regulation has ever served a prison interest. They have come up with a post hoc speculative reason to justify a restrictive policy. The interesting thing I'd like to talk with you about is how deprivation is now recast as rehabilitation. It's not just that they're saying we're incapacitating prisoners and that's our substitute for rehabilitation. It's that they're claiming that this deprivation does serve a rehabilitative purpose. Now, since the twin tags of rehabilitation and prison security justified the reasonableness of the ban on photographs and secular newspapers and magazines in this case, we can see how far the court has moved away from a broad concept of a prisoner's constitutional rights. One person's or 6 justices' reasonableness is another's madness. In his dissent, Justice John Paul Stevens, joined by Justice Ruth Bader Ginsburg, the only 2 liberals left on the court, warned that the prison regulation comes perilously close to a state-sponsored effort at mind control, arguing against its rationale, even when applied to prisoners deemed the most recalcitrant and dangerous. He emphasized the dangers in the policy's possibly limitless applicability. It would provide, Stevens wrote, a rational basis for any regulation that deprives a prisoner of a constitutional right, so long as there is at least a theoretical possibility that the prisoner can regain the right at some future time by modifying his behavior. In her dissent, Justice Ginsburg put that control into stark relief. Prisoners are allowed to read Harlequin romance novels, but not to learn about the war in Iraq or Hurricane Katrina. For the Supreme Court of the United States, talk of private experience and subjective mental states, the kind of thing that so concerns me, the personhood of those we deem to be outside of our empathy, has become irrelevant. We're so far here from the days of the Warren Court, and I suppose some people think there's undue nostalgia or not enough nostalgia, it depends. But the Warren Court at least paid attention to psychological anguish, dignity, and human worth mattered. Imprisonment is a highly abnormal condition, and nowhere as much as in these special management units. Prison behavior is artificially isolated and expected to be isolated as much as possible from normal human experience. But induced helplessness, radical isolation, and what I would argue are refinements of behavioral experimentation are legally now made a part of incarceration. A tool of mind alteration that used to be called torture is now dubbed rehabilitation. As I said, most lawyers disdain reading philosophies of personhood into rules of law. And in tandem with this, recent Supreme Court decisions do not recognize subjectivity or subjective pain or suffering. It's very similar to animal rights problems as legal matters for constitutional claims. New anomalies are legally created, and I'm really interested in what these anomalies look like and what their purposes serve. For if, as one official explained to me, prisoners are nothing but animals that we turn into senseless bums, it seems to me that legal analysis and our own understanding must begin to attend to the unique taxonomy, the new kind of being that is being created. If you create harrowing conditions of confinement, as here in the indefinite solitary in Pennsylvania, does not the treatment then fulfill the assumptions of those who have called inmates senseless bums? Reducing inmates to the most basic needs, the prison regimen then, under sign of rehabilitation, cauterizes and purges prisoners of anything that is metaphysical or cognitive. Now, this deliberate engineering of hopelessness seems to lie outside of legal claims. What Justice Stevens condemned as theoretical, a mere theory of rehabilitation without any evidence, is based, perhaps, on a peculiarly American form of torture, which is behavior modification through sensory deprivation. The human person can be destroyed without leaving any physical marks. We must think about these supermax units, which are, as I said, so costly to operate and are increasingly built to house many who are not guilty of violent crimes and who have committed no disciplinary infractions while in prison. We must ask, what happens when punishment doesn't harm the body but seizes upon the mind? And Stevens reminded the court in his dissent that prisoners are humans who have no means now of developing their mind. If they are emptied of their inner life, they are, as Stevens wrote, also isolated from any contact with the outside world, and that means this case, which received only a column in the New York Times and certainly is not very well known, this case strikes, as many have said, at the core of the First Amendment rights to receive, to read, and to think. Now, there are certain things about personhood, it seems to me, about what it means to be a person that are not lost with conviction. And I guess my question finally is, how far is the reach of personal identity if criminals are legally degraded? Not only do they lack the civil capacities of free citizens while in prison, which is expected, but given the nature of the deprivations enacted in Beard versus Banks, they may well face a degraded status even when free. In a penal system that has become instrumental and is incarcerating ever more of those we think of as dispossessed, unfit, and dishonored, I think we should begin to reconsider the meaning of the words in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Thank you very much. Thank you for bearing with me. I don't know if you expected to hear a talk. I think you did know that you were in for a talk on the searing nature of the current prison system. But I do just want to say in closing why it seems to me to matter so much and why it's increasingly mattering. I am convinced that when laws begin to allow new and unprecedented deprivations for those we call prisoners, who are called, and perhaps in many cases are criminals. Something happens to our legal system, and it becomes an example of deprivation that can be easily extended to others who have not committed crime. I mean, I do think that the law matters, and it sets precedents and creates examples that certainly, I think, matter to us now. No matter what your view is of Guantanamo Bay, it is an unprecedented experiment to detain people indefinitely without having any crime committed, only considered to be threats. I think there are 245 detainees left in Guantanamo now. But I think we should also be concerned, and I am really concerned, as a proud American, I'm really concerned about the way in which what's happening at Guantanamo and what's happening in our prisons reflect on who we are as a country to the entire Western world. I mean, pause and think. In 2002 and 2005 and in 2007, and I don't think these are left-wing organizations, we can't dismiss it easily, Human Rights Watch, as well as Amnesty International, ranked the US in its prison practices with China and condemned the abuse. I think the other thing is the question of what we think about cruel, inhuman, and degrading treatment. And I guess it is interesting, and I'll end here, that Hannah Arendt, the great legal historian and political theorist, always reflected on this curious fact that human rights organizations came into being in England at the same time, or rather after, animal rights organizations had been formed. And the human rights organizations used the same language. So I think what is interesting about that is that this is not just something that I think we can ignore, but I do think there is something afoot in this country. I do sometimes wonder if all the animal rights to do, and there's a great deal of it. I was just at a retreat about animals, 4 days of this. But I mean, I wonder if there's not some sort of bizarre displacement going on where we care so much about dogs and animals, but we really are no longer thinking about our fellow citizens. Thank you. I welcome questions. Yes.
It seems that, with the idea of rehabilitation and also the idea of kind of effective interrogation practices, someplace like Guantanamo, you enter into kind of a tautological process where because it's effective, because it rehabilitates, it's not illegal. Because it's not illegal, we're allowed to do it. And it seems to be kind of this inescapable circle. I was wondering how you, I mean, if there's any universe that should be free of tautology, it should be a legal universe, you know, and I'm wondering how you would propose to kind of maybe escape that argument.
That's a wonderful question. It is an important and crucial one. How to escape from what I think you've just pointed to what is really significant about legal reasoning and its results. I do not have a solution to that, what you're calling the tautological kind of bind that occurs.
The only solution was one you gave at the end with these truths be self-evident. The idea is self-evident is ground floor. And
exactly. Well, are you a lawyer? Are you a lawyer?
No.
Good. Okay. No, just because because the question is so good. It is often when I teach cases to undergraduates, and they're very often English majors, but I find that looking at a legal case is one of the greatest ways to begin to read closely. Because even undergraduates who've never looked at a case will say, wait a minute, this looks like cruel and unusual. Isn't this cruel punishment? But there is something about the law that makes what should be self-evident less than evident. And that's what I was trying to talk about the legal reasoning, which is so interesting, in that it does seem to use a standard of reasonableness, which is not always what we think of as evident or obvious. It defines pain and suffering in ways that I think reasonably would be related perhaps to the precedents that concern prison security. But something does happen to that, to our own understanding and ability to read these things. And I will point you to a document, if I might be so bold, that actually exemplifies what you've just mentioned. And it's the so-called torture memo that's so much been written about, of August 2002, that Jay Bybee wrote, but it was mostly pushed by John Yoo. When you begin to read the definition of torture there, you realize it's a circularity through defining where you are really locked down in a prison house of language. And I mean, I think that some legal theorists would say, well, in this case of torture, you just don't even start defining it. Because once you begin to define it, the more you make it precise, the more you try to define, is it organ failure, the more arbitrary it becomes. It's also a slippery slope. But I do think there's another reason just to think about why this kind of reasoning, which seems maybe to be or should be kept in the precincts of a law classroom, should be really shared and thought about carefully. And that is, and I wonder if this is, you know, a concern that maybe is over-exaggerated. The Military Commissions Act of 2006, which George Bush signed into law, basically says, and I'm sure you've heard this, that anyone the executive thinks is a threat can be detained indefinitely without cause, without due process, and with no habeas protections. That means that any citizen, you know, any American citizen can be detained upon suspicion. And so I think that there is a matter for concern here, because we know that throughout our heritage there have been people who did not agree with the government that was in power at the time. We know that what distinguishes our country from other places is the ability, and that's a First Amendment right, to speak out. And if you are considered a threat, to have an actual possibility of due process protection, or a right to question your containment. I think that we've, as many people are recognizing, and I think it doesn't matter whether you're in the, you know, place, I don't know how to describe the Democratic Party at this point as it deconstructs, but whether you're a Republican or a Democrat, I think these questions are occupying a number of people from either side of the political spectrum. And I do think that it is in law, it is the judiciary that has the power now. And there is an alternative, some people argue, an alternative legal system being set up here. And so anyway, I just want to maybe say that some of these questions should be considered. There's that old saying, you know, we all have to be afraid when the exception becomes the rule. And I suppose many people think of criminals as exceptions. But when their treatment can become the rule, I think we all might want to think about it. So, yes?
Have we passed a point of no return? I guess I'm sort of wondering, is this a product of recent history, or is it something that has changed so fundamentally that it's really not going to go back to, say, the freer years or the sort of open years of the Warren Court or the...
Well, I think that that's a very complicated question to answer. Clearly 9/11 as a state of emergency allowed things to happen because people, quite frankly, were afraid. It's very understandable. I think what is surprising, in answer to your question, is that there is a way that people keep raising the issue, many people. What's going on with civil liberties? What about wiretapping? Why don't we know when our phones are being tapped? Many citizens are speaking out. And I guess what's interesting is that nothing is happening. And I think that's why what you're sensing, that there is something irrevocable here, or something that seems new. I mean, I was just entering graduate school, and I remember thinking back to, well, there was Iran-Contra-gate, there was Watergate, there was a possibility of people thinking that something had gone terribly awry and standing up. I don't see that now. I mean, there are moments when things happen, like, 7 prosecutors being fired from the Justice Department, other things, as you know, Abu Ghraib, those pictures. But I mean, I think that there's a way in which within our own government, there isn't any redress for actions that would have before, I think, called for some kind of hearing. And I don't have the answer for what is. I mean, some of you who have closer access perhaps to these, to the government, I don't know, might know what's happening, in Congress, what it is. I don't have that answer, but it is something that I wonder about, whether or not there has not been a sea change that is, to use a bad metaphor, deeply disturbing in our country. Again, some people have said, it's the media, that when you really turn on CNN or Fox, what do you see most? And you don't really have the kind of reporting that we used to have in the old days. I mean, you do have a lot more sound bites and juxtaposition of something we would consider rather serious with something that is much more juicy, or not at all something that has the same kind of gravity. So, I mean, there are a lot of different explanations, I think, for what you're seeing. But I do think that there is a way also that, for many of us, the idea that penal life, the idea of an image of justice that would be equivalent to punishment, is in some way necessary for us to maintain our civil life. And I do think also that, wardens that I've talked with, one in particular, Terry Stewart, who then became the director of the Department of Corrections in Phoenix, Arizona, he then ended up as part of the 4 chosen by Paul Bremer to reform prisons in summer of 2003 in Iraq. And he wrote, having been assigned to Abu Ghraib, and he was one of the most infamous of prison directors in the history of the state of Arizona. But after having helped to reform Abu Ghraib, and we saw the consequences of that reformation later, he wrote that what matters most in any place, not just Iraq, is the penal system. There will be no civil society without a penal society. And it's very interesting to me, I've also worked on Haiti, and I know Haiti quite well, that in Haiti, many of the changes that are happening now are on the level of the courts, not in the level, and the building of prisons. So, I mean, it is quite possible that as we become more global, and as our threats increase, and as wealth becomes more sharply divided, and those who are rich and those who are poor, and the threat, of course, of terror from those who are dispossessed or angry grows, I think that for many, this is the price that has to be paid. I think there are folks in England and France, however, very aware of the threats. I'm thinking of those who are running those countries who don't quite come to the same conclusions as the United States is coming to right now, since there have been calls to close down Guantanamo from all of Europe. But then Scalia says, Europe is not America, and we should not even be looking at European opinion when we think of ourselves. But then we become terribly isolated, it seems, and in our own funny way, we're going to end up being in a kind of lockdown, separate from a certain kind of empathy that the rest of the world is feeling. So, you think that we might have ended our possibility for change?
Well, I guess I'm wondering, it's just a historic anomaly in a sense. I mean, as history moves into maybe a brighter period, maybe this will go away. I mean, part of I don't know that much about it, but I believe there's part of the Constitution that says that, except under circumstances, I think it's the Fourth Amendment, that our rights can be taken away. Right,
and Lincoln certainly abrogated rights.
So maybe that's what's happening, you know, although in a very extreme sort of way, I think. But maybe that's...
The only problem is that the Civil War had an end, and I mean, it was not proclaimed to be an indefinite war on terror. I guess what's scary about this is that Cheney, in the very beginning, said it's going to be an indefinite war. It's a war like no other war. So, sorry? Did you say? No. Yeah. So I guess that's the problem, is that if there is no end in sight, then, I mean, because certainly the Japanese were detained during World War II. There were laws passed for interests of security, Knopf versus Shaughnessy, against German citizens. But those were part and parcel of, as you say, an extreme situation that was called war. And I think this war is a war that really has no end in sight. So that might be the problem with thinking of this as temporary. Well, do you have any questions about what happens to your students when they come to Vanderbilt?
Too late.
Sorry?
Too late.
Too late. Well, I hope that they all had great careers here. It's a very varied group of professors, and my teaching is very, very varied. I did want to give you an example, though, the kind of work that I am, as a professor, although not often having the opportunity to do in a classroom, am very committed to. And I thought, well, wouldn't it be fun to talk to parents for a change and see what those who are closer in age to me are thinking about what's happening in this country today. But thank you for coming.